Hello, good evening, and welcome back to LiveLaw Academy. In our previous discussion, we had started state of UP versus Lalta Prasad Vaish case, which is related to the distinction and the division between the different list for different items that are mentioned in the list as to who can legislate on the same. If you have not attended the previous video or the previous segment related to this topic, please go and watch that video. That will help you understand this one better. Okay, that has set the context of what are the different provisions from different law that we have covered for this specific topic. Then after that, in today's class, we will be moving forward to the issues and to the arguments that have been given here. Then we will go to the conclusion part, and then, as I told you in the previous class, that the dissent is also very important in this case. So we will then be talking about the dissent. All right. So moving ahead, if you remember, this discussion was with respect to industrial alcohol. And in the last class, after reading different entries that exist in different laws, we have IDRA 1951, we have 7th schedule, which has mentioned the term intoxicating liquor. But at the same time, we have multiple, different entries which may appear to be overlapping to one another. So what do we do in that situation, right? We already did discuss about different entries. I will just take you and I'll just show you the entries that you are supposed to read and refer for this case, primarily related to this topic. But I also, took you to different other entries which are also very similar to this, which gives a scope of understanding different terms, like that is to say, or to the extent of. Right now, coming to today's class, why is alcohol or industrial alcohol, potable alcohol, or non-potable alcohol important? Okay, so first is the term I have used right now is potable alcohol, or it can be non-potable alcohol. What is the meaning of these two terms? So we understand one set of alcohol is the one that is used as beverages, right? So the one that can be consumed directly by people can be considered as the potable alcohol. And there are different products in which you will find alcohol is present in different forms, that is called as non-potable alcohol. So the simplest example can be your perfumes. You can talk about sanitizers. These are different examples, medicinal purposes, wherein you see the industrial alcohol is used, right? So there is definitely a distinction. Then when we refer to Article 47, when we refer to other entries from list 1 and list 2, we understood that we have very clearly mentioned in certain entries, industrial alcohol, which is for meant for human consumption. So one category in your 7th schedule, this is the copy of 7th schedule. Okay, if you remember, we did go through this in the previous class. If you see, very clearly certain entries use the term that alcoholic liquor for human consumption. All right, while this is so used, it is not used for human consumption, is something which is not used in the entry that we refer to, that is entry 8 from the state list, right? So that is how this confusion has taken place as to who would be making laws, who would be regulating industrial alcohol. Now, why is industrial alcohol so important? As I told, it is present in different products that we see. There are different industries which deal with the alcohol or the raw material of alcohol or the final product of alcohol. So in that situation, it is to be regulated, the revenue that is to be generated, what should be the law for regulation of the same, what is the possible scope wherein it can be misused by different people. All of this is to be assessed, right? So if I have to mention certain reasons, I'm writing that the revenue that is generated by the production or the sale of alcohol, then we can talk about that, what is the impact of such alcohol on humans, right? On human. Then we also understand that there are various products which are floated in the market which contains these ingredients. So that is how the tiff or the the fight that you see here between the union suggesting and stating that it should be regulated by the union government, while the state has asserted that it should be regulated by the state government. So these are various roles that alcohol plays in the categorization as to the development as well as for the preservation of right of an individual, right? So all of this has been there. Then I already suggested and I already shared with you in the previous class as to how this alcohol is this judgment is based on the opinion given by a bench comprising of 9 judges, and the dissent is very, very, very important for us, largely explaining each point and coming to the conclusion. So I'll take you to that particular chunk also, wherein we compare and see that what has been the reasoning for the majority opinion and what has been the reason for the dissent that has taken place. We already referred to section 18G in the previous class. We referred to IDRA 1951, wherein we went to 18G. The summary of 18G, if I have to tell you again now, will be that whenever the central government feels, okay, so it is the central government may by notification. So we did discuss this, that they can declare, and it is there, the discretionary power is there. I also told you about that regulation by forbearance exists. If you see this provision, then the central government can do that with certain scheduled industries. And when we go to the schedule 1, we see from schedule 1 entry 26, it talks about fermented industries, wherein we see alcohol is so mentioned, right? So all of this gave us an idea that this has been made keeping in mind entry 52 of list 1. And when it has been so done, should it not be the union which should be regulating the industrial alcohol? We also refer to different terms that have been used: manufacture, raw material, production of it, or sale of it, purchase of it. All of these are different terms covered at different stages in different entries. All right. These are the two very relevant judgments which I will be discussing at the later leg of the discussion, which have been, which have been dealt by the case, in this case, by the court. And we will also see how they have said that, how this is not so relevant here, and how they have tried to overrule this judgment by the 7 judges bench. Okay, so I'll come to this discussion. Don't feel that we have missed on it. All right. Now, what are the primary issues in this case? I am going a little far, because we have already covered these topics. So whatever I have done so far is the revision that I have done. All right. Now, coming to the core issue that exists in this particular case. Firstly, whether intoxicating liquor mentioned in the state list includes non-potable alcohol. As I was, telling you that intoxicating liquor has not been defined. All right. You do not see this definition either in the constitution. You do not see this definition existing in any of these laws, right? So how do we define this term? Secondly, when you come to a certain definition, you have to find out whether it will include non-potable alcohol or not. Okay, so intoxicating liquor will include industrial liquor or not. So industrial liquor is the one that is used for industrial purpose. Potable liquor is the one that is used for consumption, right? Simply, if to understand. So whether intoxicating liquor, now get the idea. The judgment revolves around the concept of possible misuse of alcohol. So we understand that there are, certain categorization, which is, which very certainly leads to the potable effect of alcohol. So one can be the cause and effect as to what is the effect of consuming alcohol. What is the effect, right? If you feel intoxicated, that can be one of the definition. Now, the loophole here is that there are various misuses by which even industrial alcohol is used as an intoxicating alcohol. So what do we do in that situation? Did you get an idea? Firstly, when we talk about the effect of beverages or intoxicating liquor considered as beverages, we understand that we will categorize it as intoxicating liquor because it has some some after effects on us. So when we consume it, we will feel intoxicated. That is one part. The other is, even if it is not an intoxicating liquor, you may still feel intoxicated. The effect may still be intoxicated because of the misuse, possible misuse that can be so done. So that is why this becomes relevant for us to find out whether, what is the definition, wherein we will you refer to the 4-prong test, then whether it includes non-potable alcohol or not. Okay. Secondly, whatever we decide in the first question, then comes that whether entry 52 of the union list overrides entry 8 of the state list. We already covered, but if I have to tell you, this talks about industries. And we did refer to various other entries to understand that this industry here means any general industry. They have not used any adjective or prefix for the industries, and therefore entry 8 basically talks about intoxicating liquor, production of liquor, manufacture of liquor, etc. Right? So here the question comes that if, let's say, there is an industry which deals with intoxicating liquor, which one will be having the authority, whether it will be entry 52, which will supersede entry 8 of the state list, and accordingly it has to be seen and it has to be dealt by the union government, or it will be considered that this is a special entry and therefore this special entry has to be treated accordingly. Okay, so this is the way by which we are going to navigate and find the answer to the second issue. Then the third one is whether a notified order under 18G is necessary to occupy the field. What has happened here is, when we were referring to 18G, I just gave you a summary. By notification, by a notified order, the central government has been given the authority that they can legislate, they can make the law, they can regulate any industry in public interest. Now comes the core question. Is this power so wide in nature that you can take away the authority of the state government, or does it have to be restrictive in nature? Okay, so if the notified order is made, whether it will have whether it will be encroaching the power of the state government, or does it have to be taken individually, we will say that whether 18G is exclusive of the entry, that is the state government entry or the entry 8 list. Okay, so these are three questions that we have to understand and that we have to find the answer to. Now let me take you through the arguments and let's see that how both the parties have tried to convince the court as to what type of interpretation is to be opted for and how it will be beneficial. So before I take you to the argument, just to understand and brief about it, let's say one argument can be on the concept of public interest. Now, what I'm doing right now is telling you how to think. All right. When we talk about public interest, one way of seeing public interest can be that we must ensure that because Article 47 is there, and we also see that it is, the state government is covering the intoxicating liquor. In such a situation, public interest should be given a wider import, and the state must be given the power to regulate. What will happen if the state start regulating? Because there is a lot of misuse that happens, and if you give the power to the state for them to expand their horizon and to regulate all these laws related to, or all the rules related to the scrutiny of how intoxicating liquors will be produced and etc., it will be actually in the benefit of public interest. So the reason of me telling you this here is that whatever term you are referring to, whether we talk about intoxicating liquor versus intoxicating liquor for human consumption, public interest, by a notified order, all of these terms are relevant for you to understand the reasoning of the judgment. Okay, so try to get hold of it. See, if you're getting a question in your exam, definitely you will not be asked to write the arguments, or you will not be expected to write what has been, how every argument has been dissented. But what is important here is for you to understand the law. Your problem-based questions are nothing, but all those lengthy questions are full of facts. Each fact, each important term has a value, and you have to accordingly interpret and read it in context. And that habit will come once you start getting into the reasoning of the judgment. Okay, so that is why I have highlighted this here, that every term is going to be important when you are reading the judgment. Okay, so if, as you can see, the state would want that wider interpretation should be given to the term intoxicating liquor, and it should include industrial as well as spirit, the denatured spirit. Okay, then also, because there is no definition now, when the statute doesn't define something, let me tell you one thing. In the previous discussion, in just the previous class that we did relating to the introduction of this topic, I told you already that we have to see the intention of the maker. You will see that the judgment has quoted these terms. Okay, intention of the legislature has been quoted in the judgment also. Sorry. So now what we are telling here is that while we are talking about this term, we have to also ensure, and we also have to see that if the term has not been defined in the statute, your first take is that you go and see the definition in the statute. If it has not been so defined in the statute, then you try to take help of the other sources. Okay, so when you're trying to take the help of the other sources, one party may say that it has to be given wider interpretation, the other may say narrow interpretation, depending on the the objective of the law, depending on the concept of public interest, utilitarian principle, all these things that are there. Okay, so relying on several statutory definition, what has happened here is, as I told you, you will try to look for the definition from other places. So you will see here that the Constitution Assembly debate has been referred to. We have also referred to the Government of India Act 1935. All these are what? All these are external aids by which the judges have tried to take help. The judges have tried to rely and see that how have we really defined the term industry? What do we call is industry? What do we call is intoxicating liquor? And that is how you see when I just showed you in the beginning of the class that intoxicating liquor versus intoxicating liquor for human consumption. When the legislature has used these two terms, you understand, and it's not even by way of amendment, it has been there. So you understand that the idea was to differentiate between the two, right? That could be one set of thought as to how it should be perceived. But the state government here is saying that the statutory definition is not present there, and therefore we'll be referring to different set of authorities to understand the same. And we will be using purposive meaning. Purposive meaning, okay, this is one principle or one rule of interpretation wherein, we'll be talking about harmonious rule of interpretation here in this judgment. We will also see this harmonious rule of interpretation is also called as test of workability, wherein you have to see whether the interpretation that we are trying to give to this term will be working with all the other provision of the law or not. Let's say, if in one way I say that, okay, it is the state government that should be working or that should be legislating on all type of industry. So will it not make entry 52 of list 1 of any of, or a dead letter? It will just take away the essence, because you have now, by this interpretation, you are saying that all type of industries will be taken away or will be regulated by the state government. So that cannot be done. You have to harmoniously read all the entries. You have to ensure that the interpretation you are giving is working for all the other provisions as well. So that is why it is called as test of workability. The other is purposive meaning. When we talk about purposive meaning, we are basically saying that you have to see the purpose. When in Government of India Act 1935, intoxicating liquor was used, what was the purpose of the law? In IDRA 1951, just after the introduction of Constitution, we made a law. What is the purpose of putting or adding fermented industries there, including alcohol? So that is purposive meaning that has to be given, and that has to be taken into consideration by the court. Secondly, the state has also averred that merely the central government should not be given this draconian power wherein they merely pass an order, they merely pass an authority, they notify and they say that we will be usurping the power of the state government. So that should not be done. And here rather they are saying that they have accidentally stepped into the areas which are supposed to be controlled by the state government. So they are saying that this looks like a legislative error. This cannot so exist. Definitely section 18G or entry 26 of the schedule excludes intoxicating liquor. That is another argument that they have made. And therefore, when we have a system like ours where both central and state government share power, we have to ensure that the state government's power does not get reduced by a notification given by the central government. Okay, this will hamper and this will harm the balance of power. In our previous classes, we have already covered the concept of separation of power, rule of law, and I would urge you to go and watch those videos as well for you to understand the meaning of each of these terms. Okay, and then you accordingly start thinking as to how this should be applicable or not. The other opposite way by given by the central government here is that we cannot, it will not be fine for us to give a wider import to intoxicating liquor. Okay, they are saying we have very clearly used the term alcohol. When we use the term alcohol, we meant that these are beverages. If not this, we have used the term intoxicating liquor for human consumption. Here also we meant beverages. So please do not give a wider or a broader import of this term when it is merely using intoxicating liquor in the state list. Okay. Then the union has also said that we would request you to see it from the constitutional lens. As I just told you, that when we were reading in the previous class article 246, we refer to the non obstante clause and we also refer to the subjective clause. And referring to this, we understood that keeping in mind the concept of public interest, we have given this duty to the union government. So seeing it from the constitutional lens, you will understand that the distribution of power and duties is very clearly so given and it has to be accordingly understood. In addition to this, you, as I was saying, this is nothing but purposive meaning. Okay, harmonious interpretation when you talk about symbiotic relationship. So all these entries, all these different entries in different lists are in symbiosis to each other. Okay, so what do you mean by symbiosis? That is that they are all complementary to each other. So one may cover these stages, okay, and all these stages we did also. So one may cover these stages, the other entry may cover other stages, and accordingly, if you read it in this manner, you will see in essence there is a symbiotic relationship that exists between all these entries and there is no overlap as such. When we use the term industry, along with that, when we use and say that the central government may make law, accordingly IDRA has been made and accordingly it should be considered to be covering the concept of alcoholic industrial alcohol. Okay, so we have understood this. Now coming to, as I was telling you, yes, there were constitutional assembly debates that have been referred to understand that alcohol can be referred and can be understood in different meanings. Okay, now moving to the next set of discussion, we have 4 tests of determining intoxicating liquor which has been used in this case. All right, before I get into this, let me just quickly revise what we have discussed. We understood that why alcohol is such an important subject matter and why the discussion becomes important for the state per se because of the revenue impact and other factors. Then we refer to the arguments that have been taken by the parties in this case. I will also immediately just show you that what is the index all about. Okay, so this is the copy of the judgment and we see here that these are certain important facets. So first is it talks about the constitutional provisions, which we did in the last class. We refer to Article 47, we refer to 246, and we try to understand the interpretation of the same. This is the part that we have to do, wherein we'll be talking about the synthetics judgment, which was given by the 7-judge bench. Herein, there is the bench strength is 9 judges, and accordingly, this has the authority to overrule the judgment. These are the submissions that have been made with respect to potable and non-potable alcohol. So we understood how both are different. I will give you a very simple example for you to remember. When we talk about sugar versus sugar cane, there is any difference? Yes. Likewise, when we talk about, the different raw forms of alcohol versus when we are talking about alcoholic beverages, whiskey or whatever you may think of. So in that situation, definitely there is a difference between the two. So that distinction has to be seen. What are the issues we have understood? Then comes this analysis part. Okay, let's just take some time and try to understand it. This will give you summary of, what you are supposed to write in your answer. So what is the scheme of legislative entries? As I told you, you always have to see that the constitution was framed and these division of powers were done keeping in mind as to which government should be regulating which particular entry, right? So constitutional distribution has been done, demarcation has been done, and that has to be respected. Secondly, in no situation the central government or the state government can go against it, and if they do so, that law will be considered as unconstitutional. Then what is the scheme of legislative entry? So we try to understand that why industries have been mentioned there. As we see from 18G itself, it talks and it covers the concept of equitable distribution, okay, or availability. Then it also talks about fair prices. So very clearly, IDRA says that the central government will come and say that I will be regulating this industry when they see that, the requirement of equitable distribution is there, the requirement of fair prices is there, So that is why it becomes very important that you have to see the scheme of each entry that has been made, and accordingly why one has been kept in different places. Okay. And then we have to see the scope of entry 8, which is made in the list 2. We have to see whether it is industry based or it is product based. So as we discussed and as I told you, one important factor here is that entry 8 uses the term intoxicating liquor. It does not use the term industry related to intoxicating liquor. So that is why the confusion here is whether this entry is industry based or is it product based. Okay, so scope has to be seen. Then we already discussed the meaning of the term, that is to say. Then we also understood that this just now what I told you, product based or entry based. Then we also understood that because of the term, that is to the extent of which is present in other entry but not present in entry 52 of list 1, this becomes important, that how do we actually perceive it? Do we see that the intention was not to exclude anything and give absolute power to the union, or is it actually to put a restriction? So simply because if this is not mentioned, this basically gives an idea that this entry gives all the power to the central government, right? But whether that has been seen as the same or not is what we will find out by the end of the class. Okay. Then how do we reconcile if there is a possible overlap? How do we come to the reconciliation of the same? All right, so this is all that we have discussed in bits and part, and again I will be discussing it in the conclusion also, that if we identify that yes, there is a conflict, how are we going to reconcile this conflict is something that we will understand. Then precedent on the interpretation of the term, as I was telling you that we have to use different tests. You have to refer to the precedent and then try to understand what actually is intoxicating liquor. We have to identify the meaning of the term for us to see, for us to get benefited as to how it is to be interpreted. Then we will be seeing that what is the impact of the decision, what is the reasoning of overruling the previous judgment, and then talking about section 18G of this. So this is how you get a structure of your answer, or you get a structure of your notes from the index of the judgment. Now all of this may look as if you've only studied bits and part of it, and something other things are very new to you. I understand. Do not worry, we will cover each topic. You see, we have covered most of them, we'll be covering rest of them as well. All right, but the whole point of me showing you this is that we are going in a structured manner. We are seeing the arguments, we are coming to find out different mechanism to see the definition of industrial intoxicating liquor, and then we will go to the reasoning given in the judgment. Okay, so this is a 4-pronged test. there have been different precedents in which we have referred to different tests. We have devised different tests. When I say we, it is the judges, obviously, but I meant jurisdiction, right? The judges have devised certain tests which can help us identify whether, what should be considered as the definition of this term. So let's try to understand what is the meaning of this. So first is identifying the legislative meaning. As I was telling you, the first and foremost task is, if something is defined, first is you have to find whether it is defined or not. Secondly, if it is defined, what is the meaning of it? Because in most of the cases you will see that the definition is given, but you have to find out what is the scope of definition. Is it exhaustive in nature? Is it to be read as it is, or is it, does it have the scope of including other things? All of this. So when we see intoxicating liquor, that is to say, has been used in entry 8 of list 2, we get an idea that the definition is not there, but it is trying to explain something, right? Trying to explain the nature of products that will be used in intoxicating liquor. So we have to first identify the legislative meaning, which I've told you how it is to be done. Secondly, if that is not there, try to understand and see the legislative history. These are terms, these are tests which you can read or which you can refer for every other aspect. So let's say you are a lawyer and you're practicing, and you have to find out the interpretation of the term disqualification. Okay, let's say there is some notification that has come for higher judiciary, and the term disqualification is written. They have not explained the term disqualification. Now, how do you find the meaning of disqualification? It can be somebody who's cheating. It can be somebody who left the exam early. I'm just giving you an example, hypothetical. Okay. So how do you say, or how do you interpret this disqualification in your benefit? Some interpretation that will help you. You try to identify the legislative meaning, whether disqualification, if let's say not defined in the state rules of this state, maybe in the other state that has been used. So you try to see the legislative meaning, or you try to see the legislative history. What has been the reason? If there were debates, if there were parliamentary debates, what has been the reason to use this term? So accordingly, you can get into the history of finding out the meaning of the term. Then the common parlance test, very important. Common parlance is commonly used. How is the term commonly used? How many of us have ever used the term intoxicating liquor for a alcoholic beverage? None of us, right? Mostly nobody would have used that. I want to buy an intoxicating liquor today. No. So that is why we also have to see how in common parlance this term is being used. So none of this can be the exclusive ground for you to say this is how it is to be seen. But all of this complementarily can, help us come to a conclusion as to how we are supposed to perceive the term. And the fourth one is principle of workability. You have to see how the term works, how the interpretation works, whether this will benefit, or will it take away the essence of other sections, other articles, other entries, or will it be in consonance of all the other different provisions that are so there. All these are factors or principles of workability that also can be seen. So these are four tests, or the four prong test that has been used by the court in this case. And these are different meanings, okay, which we will now see what is the explanation of all these terms. So when we talk about legislative meaning, we have seen that the principle of interpretation says that we have to see when we are talking about legislative meaning, we have to see the legal definition of a disputed term, okay? And when only when it is appropriate, we have to see that whether the legal definition aligns with the common understanding. If let's say the legal definition has some loophole or has some ambiguity, then what will you do? Will you simply jump to common parlance? No. You have to then see whether the interpretation I am trying to give to this term is conflicting with the common understanding, or is in consonance with the common understanding. Okay, so that is the one way of seeing how these cases are to be, or these definitions are to be assessed. Okay, then the court here has said that in common parlance, the intoxicating liquor means liquor which causes intoxication, that it causes someone to lose control. So one way is, when we say intoxicating liquor, it is something which will have the effect of, this is based on effect. What effect is that going to create in that situation? This is how majority opinion is seeing the term intoxicating liquor. They are basing it on effect. They are basing it on common parlance. They are saying that we have to see if the term has not been used, how in common parlance the term is to be construed. And in common parlance, they are saying that it can be construed as on the basis of effect of the liquor. Okay, now the dissent part is wherein Justice Nagarathna says that no, we can't be doing this. We have to see what is the usage of it. Okay, usage of it, whether it is for consumption or whether it is not for consumption. If it is not for consumption, then definitely we will not consider it as intoxicating liquor. So as I'm telling you, two ways of trying to see the same term. Okay, you can be the judge, you can be a lawyer to either of the parties, or you can be the judge deciding on, in coherence with the majority opinion or the dissenting opinion. That is on you. But here we are trying to understand how it has been seen differently by in different opinions. Okay, then for legislative history, all these different documents were referred, as I already told you, and therefore the majority said that definitely from reading all of this we understand that when they use the term intoxicating liquor for human consumption, they meant something else. When they use the term intoxicating liquor, they meant something else, right? So distinction definitely exists between the two. But Justice Nagarathna has again contested this opinion, and she very clearly says that, see, the intention of legislature has been very specific. Okay, they have been very clear by the terms that they have used. It has been cautiously done, and we always have to believe that it has been cautiously done. And secondly, she says that when the framers have chosen certain phrases, we have to ensure that the contours of interpretation must be concerned with just that, rather than entire industry concerning alcohol. So she is saying that, as I was telling you in the previous class, when with the literal interpretation, with the literal meaning, there is no conflict. You do not have to expand. Okay, with just that, just try to stick to that. Do not try to expand it. Do not try to increase the horizon if it is so not needed. Okay, so that is the dissent that is given. Then common parlance is something that we already discussed, and then we talk about harmonious interpretation. As I was telling you, if we start believing that it is only the state, it is only the union government that will be regulating all of this, so in that situation you will be taking away the power from the state government, as well as you will be putting the entry 8 of list 2 in nugatory. That means it will have no essence only. Then what is the point of having Article 47? Why are you saying that the state has to, ensure that there is public health is maintained, and they have to regulate how intoxicating drinks have to be seen? So all of this that has been done, also this article 366 that have been referred, which talks about the definition, and then they talk about the definition of this term for taxing purpose. So in all these situations, we see and we identify that the court says that the interpretation has to be given in a manner which is harmonious and which does not go beyond the actual meaning of the term. Okay, then the next part here will be that there was a 7 judges bench judgment, as I told you. I showed you also this in the beginning. This 7 judges bench judgment said that the state government cannot, okay, the state government cannot regulate potable alcohol. So when we use the term intoxicating liquor, we do not mean potable alcohol, and therefore they are only supposed to regulate. Sorry, I meant the other thing, that they are not supposed to get into the industrial alcohol, because industry is very clearly mentioned in the list 1, and they are only and only given the power to be restricted to potable alcohol, and that will be sufficient in the interest of public health. So we will discuss that this guise of misuse. Okay, under the guise of misuse, you can't take away the essence, or you can't take away the meaning of the law. So just because you say that we are apprehending or we are under fear that it can be misused, consumption can be misused, you cannot really say that industrial alcohol has to be regulated by the state government. Okay, so this is something which has been discussed in the previous case, and accordingly it has been seen in the judgment. All right. Now I am taking you to this table that we see is there in the end of the judgment. You can get the copy of the judgment from LiveLaw, and there you can access this judgment. You will see that the table talks about why the majority opinion has said something and how it has been, the different opinion has been given by Justice Nagarathna. Okay, so my conclusion is, because this is the latter part of the judgment where she has written her dissent. So we will now get into each discussion, first, second, third. If you have not attended anything, this can be the conclusion for you to summarize and for you to find answer to each term that we have understood. Okay, so firstly we talk about entry 8, and we have acknowledged, the majority has acknowledged, that it is both industry and product based. Okay, because they have used the term, that is to say, this gives a wide expansion and wide import, and therefore we can include both industry and product here. This is the first interpretation given by the majority. But on the contrary, Justice Nagarathna says that it should not be so. We have to ensure that these industrial alcohol as intoxicating liquors can also be controlled and prevented under entry 8. And also we have to ensure that Article 47, which is already there, is giving the power to the state, right, for the possible misuse that can happen. So this is not a right way of construing or going beyond and saying that the merely that is to say, which is the term that is used, will expand the meaning of the same. Then the second is related to doctrine of occupied field. As I was telling you, if one concept or one item is occupied by the union government, there is no point of the legislature to put the same under the garb of state government. They will not do so, because they understand that will be making the other entry nugatory, or making the other entry have no legal effect. So that is why we understand the doctrine of occupied field, but the majority says that the parliament cannot occupy the field in the entire industry merely by a declaration. So it will not be okay that by declaration the parliament takes away all the power. That will be draconian in nature, and therefore we have to ensure that the parliament can make law for all industries except the industries that is so mentioned in the list to our entry 8. Okay, that is given. On the other side, Justice Nagarathna is saying that Parliament can occupy the entire industry merely by issuing direction. That is written. You can challenge that the entry itself is not correct. But how are you challenging the law that has been made on a valid entry that exists in the Indian Constitution? So the state is not denuded of the power. State has its own restrictive power, and therefore the parliament under has the authority to make IDRA, which is absolutely fine. The third one is related to parliament does not have the legal competence. So definitely we already understand that there is separation and between who will legislate on which subject matter, and Justice Nagarathna also has agreed to the same. So whatever industry of intoxicating liquor is covered in entry 8 in the exercise of the power 246, it cannot be taken away. Definitely that cannot be done, but if the law has been made, then it can do so, right? So that is another discussion. Then the discussion is with respect to the definition and the precedent that are so used. So we in the majority here says that not only we see that what is the popular meaning of the term and whether it includes alcoholic beverage, we also see that what is the effect. If it is going to cause noxious effect which will be detrimental to the health of the people, we will definitely ensure, the state government will definitely ensure and regulate in such a case. But again, the dissent here says that this is a very wide meaning that has been given and it should not be so. If we refer to the popular meaning, we will understand no common person, no person who is, a reasonable person will say intoxicating liquor for an alcoholic beverage. So in common parlance, it is not so accordingly seen or perceived. Then the two-pronged test, as I was telling you, that if the definition has acquired any meaning or not. So if, let's say, the law defines something, then it is something that we go ahead with. If not, we see the popular meaning and then we try to see whether popular meaning is complementing the legal meaning. Okay. So here the majority says that we have not, so far we have not attained any popular meaning, and therefore we have not fulfilled the two prong test as mentioned in this case. On the other side, Justice Nagarathna is saying that it has acquired a legislative meaning, and therefore we must stick to the legislative meaning that is to be granted to it. Okay. Then very clearly majority says that we have used intoxicating liquor and alcoholic liquor for human consumption, and we are acknowledging that this is a well thought decision taken by the Constituent Assembly. But at the same time, we also acknowledge that they were aware that both can be used, and accordingly they have put the it in different categories. Not absolutely right. Justice Nagarathna has rather said that if you see the term intoxicating liquor in entry 8 list 2, this is also evident from 26 of Ditna that intoxicating liquor is only a segment of fermentation industry which includes potable alcohol. So she sees that when you do harmonious construction, you will see that while intoxicating liquor is used in entry 8, at the same time we have our IDRA, and there we have used the term potable alcohol or alcohol related to which there is a fermented industry. So there is definitely segregation, and that segregation is not seen by the majority. Okay. Then we also have discussed about the concept of public interest. The majority said that if we have to actually see that the motive has been public interest, then in that nature it will be always better that you expand the power of the state government so that they can regulate, and there is no using of the noxious material for the detriment of public health, because a lot of these substitute of alcohol is used as drug for the effect of intoxication. Justice Nagarathna says that the potential misuse of alcohol cannot be the basis of interpreting an entry. Just because you fear that there can be a possible misuse, that should not be allowing, or that should not be the reason of you reading or interpreting the law in a other manner. Okay. Therefore, in conclusion of all of this, the court has held that it is the state government that will have the power. I'll just show you. Therefore, all these discussions are something that we have done. Okay. So the court has held that it is the state government which will have the power uh, to legislate on the concept of the intoxicating liquor, as well as it will include industrial liquor as well. In addition to this, they have said that all of this is based on the principles that we have applied, and accordingly it has to be seen that whatever is mentioned in 18G and whichever is there in the schedule of IDRA, it excludes industrial alcohol. So the government cannot by notification take the power of the state government, and this specifically now onwards will be read as it excludes the regulation of industrial alcohol that so exists. So with this, we are done with this case. Very important, relevant landmark judgment. A judgment given by a bench comprising of 9 judges. Very important for your constitution law. Very important for your understanding of how to understand or how to read judgments, how to read law. I hope this has been beneficial. And if you have any doubt, you can definitely leave your doubts in the comment section. Try to write your answers also in the comment section. And if possible, and if you want us to cover any judgment which has been recently given or any landmark judgment, feel free to write it in the comment box, and we will be covering that topic in the upcoming classes. Thank you so much, all of you. I'll see you again with another important case law. Thank you.